Good morning. For examination purpose, another important topic was how to mark the documents. If the document is being marked, what all are the test of objections? What all are the test of objection removal should be kept in mind. So for that you have to go through Indian Evidence Act, the Registration Act and Indian Stamp Act. See, Registration Act says under section 17 there are two categories of documents which are two set of documents to be registered. One is compulsory registration is necessary, another one is optional registration. So that has to be looked into. Tamil Nadu government has recently amended a Registration Act by inserting 17(1)(g) that all agreement for sale should be registered. So for that I will just read the judgment. AR 2023 Supreme Court 1895, AR 2023 Supreme Court 1895. Therein the R. Yamalata versus Kasturi, the Supreme Court has held that even if the registration is compulsory for agreement for sale, but in view of section 49, that document may be marked as well as it may be marked for collateral purpose. So for that you go through the judgment, keep it on file. So what all are the objections should be referred for marking the document? Number one, you should kindly verify the document is primary or secondary. Is this original or secondary one? If it is copy of the extract, then you should ascertain whether it is from the proper custody or not. These things should be looked into referring Indian Evidence Act. So far, Registration Act is concerned if the document is compulsory registrable, that if it is not registered, the document should be rejected, should not be marked. Then question arises Indian Stamp Act. Indian Stamp Act says if the document is not sufficiently stamped, then it should not be marked, it should be impounded and levy a fine by a revenue authority should be looked into. These all are the most important things you should keep in mind at the time of marking documents. Even if you are conducting criminal cases, civil cases, negotiable instrument cases, domestic violence cases, family court, because for family court Indian Evidence Act may not be completely relied or followed. So these things should be understood. I hope you kindly follow the judgment AR 2023 Supreme Court 1895 R. Yamalata versus Kasturi. See, so far the recent development, what is happening in Tamil Nadu. I want to refer two cases, two historical events. Number one, when Thanadi Pillai was Minister for Veerapandya Kattabomman, he seems to have looted the civil supplies godown of Britishers and distributed to poor people. Therefore, the British commander sent a warrant of arrest to the Veerapandya Kattabomman. Veerapandya Kattabomman refused to hand over Thanadi Pillai, and that resulted war between Veerapandya Kattabomman and British people. This is what had happened. Like that, several wars was due to holding the responsibility of the culprit. Admittedly, they are culprit. This is what the history repeats itself. This is what happening. I do not want to mention more than that. I am just reminding that this should not, otherwise See, even though he was a minister, he acted indifferently, inhumanly, not unbecoming as a minister. Minister should be a role model for the public as well as for common people as well as the king. But Tanadi Pillai seems to have done that. This is what I want to refer to you. Okay, today that's all. Best wishes.